You know about LLCs. But there's another structure most have never heard of, the Private Membership Association, or PMA. It can offer flexibility from many public regulations, giving members more autonomy and deep privacy. Its legal basis is so strong, it was a main component of the civil rights movement, upheld by the Supreme Court. Today, it's a potent tool for entrepreneurs and individuals who want to protect their privacy and freedom. So, are PMAs a good choice? We'll break down what they are, their benefits, and the critical risks you must know. First, what is a PMA? It's an organization that operates in the private domain, separate from the public, for the benefit of its members. Unlike an LLC, you don't file with the state. A PMA is formed by a private contract between members, outlining their agreement to associate. But how can a simple private contract be so powerful? Where does its legal authority come from? The answer is coming right up. The answer is in the U.S. Constitution. A PMA's authority isn't granted by a state. It comes from fundamental, constitutionally protected rights. This includes the First Amendment right to association and speech, and the Fourth, Fifth, and 14th Amendments, which protect privacy and private contracts. So, a PMA is a contract-based structure protected by the Constitution. What does this actually mean for you and your organization in practice? The structure gives you genuine autonomy. Members can establish their own internal rules, standards, and procedures without outside agency permission. This also creates powerful privacy. Since it operates privately, a PMA can shield member data and activities from public disclosure requirements. Benefit 1. This privacy allows for greater freedom in how you communicate and market services to your members, outside of public scrutiny. Benefit 2. It naturally fosters a strong community. Members are joined by a common interest and a private agreement, which builds trust. Benefit 3. The governance is highly flexible. You create your own bylaws, customized to your members, not using rigid state templates. So who is actually using this structure? Let's look at some real-world applications to see how it works. PMAs are a powerful instrument for practitioners in fields like alternative healthcare, letting them offer services under private association rules. They are also used for private education co-ops and learning pods. This gives members more control over curriculum and teaching methods. Significantly, they provide a framework for groups to operate under private agreements, allowing them to bypass certain public mandates. The pattern here is clear. This is about exercising the freedom of association and private contract. These aren't loopholes. They are applications of basic rights. This sounds incredibly potent, and it is, but it is not a magic shield. So what are the catches? What are the risks you absolutely must know? The single biggest risk compared to an LLC is liability. In an unincorporated PMA, members can face personal liability for the group's debts. Risk number 2, the tax myth. A PMA is not automatically tax exempt. Claiming this improperly can lead to huge trouble with the IRS. Risk number 3, the magic shield. Myth. Courts look at your activities, not the label. It can't shield fraud or things that cause public harm. Risk number 4, limited public appeal. The very exclusivity that makes a PMA strong can also limit its growth and market reach. So we have incredible freedom on one hand and serious risks on the other. The answer is found in a fundamental trade-off. Recall that a PMA is formed by private contract, not state filing. That is the source of its freedom. But because the state didn't create it, the state grants no liability shield. And the constitutional rights? They are strong but not absolute. The court's focus on substance means your right to associate ends where harm or fraud begins. The ultimate takeaway is this. A PMA is an instrument for claiming autonomy, not for evading responsibility. You take on more risk for greater control. Think back to the civil rights movement. The right of association wasn't used to avoid laws, but to stand for a principle when public laws were unjust. That is its true spirit. So, are PMAs worth it? For the person who values privacy, autonomy, and community above all else, the answer is a firm yes. It is a viable alternative. They offer a unique framework for protecting individual liberty and operating by your own principles, but only if you accept the duties that come with that freedom. Choosing a PMA isn't just a legal decision. It is a declaration of self-governance, a commitment to your members, and a stand for your right to private association. If this idea is for you, do your own deep research. Consult with professionals to decide if this path is right for you